The silence in that boardroom was the specific kind that only exists when 37 people are holding their breath simultaneously. I remember the exact temperature of the air, 68 degrees, the kind of institutionalized chill that conference room thermostats are calibrated to maintain so that executives stay sharp and adversaries stay rattled. The mahogany table stretched 22 feet from end to end, its surface so lacquered it reflected the faces of every man seated at it, like a dark mirror. A boardroom of doubles, everyone staring at their own terrified reflection. I sat at the far left corner, a seat that no one wanted because it placed you directly beneath the projector's fan unit, which exhaled warm, recycled air in rhythmic pulses. I had chosen it deliberately. From that angle, I could see every face in the room without moving my head. His name was Garrison Holt, and he was laughing. Not a performative laugh, not the strategic chuckle that executives deploy to signal dominance. This was the involuntary, full-body laughter of a man who genuinely believed he had already won. He leaned back in the chair at the head of the table, one Italian leather shoe propped against the mahogany edge, his tie loosened, his jacket draped over the chair behind him like a flag planted in conquered territory. The digital display behind him showed the Meridian Tower redevelopment proposal in 48-point font, and beneath it, in smaller text, the names of the minority stakeholders who had no idea they were 48 hours from being systematically dismantled. I watched him laugh. I did not blink. And I thought, he doesn't know I own the trail. To understand how Garrison Holt lost a $400 million redevelopment portfolio in the span of one board meeting, we have to go back 11 months. We have to go back to the Tuesday morning when a courier dropped a sealed evidence package on my desk and changed the temperature of everything that came after. My name is not important to this story. What is important is what I do. And what I do is find numbers that do not belong. I have been a forensic accountant for 19 years, the last 11 of which I spent building a practice that specialized in what the industry politely calls transaction anomaly detection, and what my clients' attorneys call the thing we pray no one does to us. I had been retained by a coalition of minority stakeholders in the Meridian Tower project, a group of 7 small investment entities, mostly family-run real estate trusts, that had pooled capital to secure a position in a landmark downtown redevelopment deal. The deal had been structured and championed by Garrison Holt, senior partner at the firm Holt, Carver, and Dade, a man whose reputation in commercial real estate law was considerable and whose name appeared on plaques in 3 different civic association offices throughout the city. The stakeholder coalition had come to me not with suspicion, not yet, but with confusion. The numbers in their quarterly disbursement reports had begun to develop a texture that seasoned investors recognize before they can articulate it a slight wrongness. The financial equivalent of a room that has been recently searched by someone careful. The disbursements were arriving on time. The percentages were correct to 2 decimal places. But the originating account numbers on the wire confirmations were rotating in a pattern that no legitimate escrow management system produces. They brought me a box of documentation and said, "We think something is off." I looked at the first 12 pages, set them down, and said, "Something is off." I had seen this architecture before. Not this exact deal, not this exact city, but this precise blueprint of fraudulent intent, and the memory of where I had seen it surfaced immediately, the way old injuries announce themselves in cold weather. 7 years earlier, I had been brought in post-collapse on a commercial port authority development in another state, after a celebrated infrastructure attorney had structured a deal that appeared, on paper, to be an equitable public-private partnership. The minority investors in that deal, a coalition of small engineering firms and municipal pension fund subsidiaries, had been positioned in the capital stack at exactly the threshold where they bore maximum risk but held minimum protective covenant coverage. When the deal's internal refinancing triggered a cascade redemption clause, those stakeholders were wiped out first, systematically and legally, while the senior insiders extracted their positions through a pre-negotiated subordinated debt exit that no one had disclosed in the original offering documents. The attorney in that case had called it standard waterfall mechanics. The court, 18 months later, had called it constructive fraud. I had called it a blueprint, and I had kept a copy, because here is what sophisticated financial predators rely on, more than any legal complexity, more than any jurisdictional ambiguity. They rely on the assumption that the people they are defrauding will not be able to read the instrument being used against them quickly enough to matter. The redevelopment contract that governed the Meridian Tower project was 214 pages long, drafted in the layered, subordinate clause syntax that Garrison Holt had spent 3 decades perfecting. It contained 31 defined terms, each of which modified the meaning of at least 4 other defined terms. It had been presented to the minority stakeholders with a 72-hour review window and a closing deadline anchored to a municipal bond issuance that could not, the coalition was told, be delayed without triggering a penalty cascade. That is the mechanism, not complexity for complexity's sake, complexity as a time weapon. By the time you understand the contract, the towers will be mine. I spent 6 days reading it. I flagged 41 provisions. I mapped the defined term dependencies into a decision tree that covered both whiteboards in my conference room. And on the morning of the 7th day, I found the escrow trail. Not one escrow account, 2. One that appeared in the official closing documents, one that did not. He thought the deal was already closed, but he didn't know I had already requested the originating bank's SWIFT confirmation records through a civil pre-litigation discovery channel that he had no way of monitoring in time. The offices of Holt, Carver, and Dade occupied the 41st through 44th floors of a glass tower downtown, and walking into their lobby for the first time felt like entering a carefully engineered argument about power. The reception area was floored in absolute white marble, a material that required constant, invisible maintenance to remain that immaculate, and which therefore communicated, subliminally, but precisely, that the people who worked here had access to forms of labor the visitor did not. The furniture was angular and low, designed to make seated guests feel diminished, while the receptionist looked down from a raised oak platform. 2 massive photographic prints flanked the elevator bank aerial shots of city skylines at night, cities that Garrison Holt's firm had reshaped through decades of deal work, captured from altitudes that made the streets below look irrelevant. I stood in that lobby for 40 seconds, cataloging it the way I catalog every room I enter in a professional capacity. Exits, sightlines, the power geometry of who sits where and why. I had requested the meeting through the coalition's general counsel, framing it as a routine due diligence call, the kind of preliminary coordination meeting that forensic accountants routinely conduct with deal architects when performing third-party financial reviews. Garrison Holt had agreed to the meeting because men like Garrison Holt agree to meetings they believe they control. He had been told I was conducting a standard stakeholder audit. He had not been told what I had already found. That asymmetry was not an accident. It was the entire architecture of what came next. He kept me waiting for 22 minutes past the scheduled time. This was not carelessness. Senior attorneys at firms like this one are maniacally precise about their calendars. The 22-minute delay was a calibrated communication. Your time is subordinate to mine, and you should absorb that message before we speak. I used the 22 minutes to review my notes, cross-reference 3 sets of wire transfer summaries I had printed and organized by originating account sequence, and observed the rhythm of the office through the glass partition behind the reception desk. Associates moved fast and kept their eyes down. Partners moved slowly and made eye contact with no one. The support staff moved with the particular invisible efficiency of people who have learned that visibility is a liability. It was a precision organism, this firm, optimized entirely around the comfort and productivity of 4 names on the door. When Garrison Holt finally appeared, he was already performing. He had the handshake of a man who had shaken 10,000 hands and classified every one of them within the first 2 seconds of contact, firm enough to signal dominance, brief enough to signal that he had more important things to return to. He was 61 years old, silver-haired, with the specific physical confidence of someone who had been told since his late 20s that he was the smartest person in every room he entered. His cufflinks caught the light. His watch was not flashy, which meant it was extremely expensive. He smiled at me the way a chess grandmaster smiles at an opponent they've already defeated in their head. "Miss Voss," he said, using my name like a handle to pick me up with, "I understand you're doing some bookkeeping work for our minority partners. What can I clarify for you today?" Bookkeeping. The word was not casual. It was a reclassification, deliberate and immediate, a move to reframe the nature of my engagement before I had spoken a single substantive word. A forensic accountant with pre-litigation discovery access is a legal threat. A bookkeeper is a clerical function. He had just attempted to rezone me in real time, and he'd done it smoothly enough that in most rooms, most people would have accepted the new designation without noticing the transaction. I let it go. I had not come to this meeting to correct his vocabulary. I had come to take a reading. I asked him 6 questions over the course of 40 minutes. The questions were structured as routine due diligence inquiries, disbursement schedule, confirmation, escrow agent verification, the identity of the wire transfer authorization chain, standard language. Nothing that would alert a sophisticated legal mind to the specific thread I was already pulling. He answered all 6 questions with the fluent confidence of a man who had rehearsed these answers so many times they had calcified into reflex. The escrow was managed through Meridian Title and Trust, a subsidiary designated in the closing documents. The disbursement schedule was tied to construction milestone triggers. The wire authorization was a dual signature protocol managed by his firm and the project's primary lender. Every answer was correct. Every answer was also incomplete in ways that only made sense if you already knew where the second set of accounts was routing capital. I thanked him for his time. I closed my notebook. And then, at the door, I paused and asked one final question, the kind of question that sounds administrative and lands like a depth charge. "Just for the file, can you confirm the full SWIFT identifier for the Meridian Title escrow account? I want to make sure my records match the originating bank's." He answered without hesitation. He gave me the number. It was the number from the official closing documents. It was not the number that appeared on 11 of the 37 wire transfer confirmations I had already obtained. The gap between those 2 numbers was not a clerical error. It was a second escrow account, undisclosed, routing capital through a nested LLC structure that terminated in an offshore fiduciary arrangement registered in a jurisdiction whose disclosure treaties with domestic regulators were, at that precise moment in history, being renegotiated. He had no idea I had the SWIFT records. He had no idea I had already mapped the LLC chain. And in his confidence, in the absolute untroubled fluency of his answer, he had just confirmed the one thing that a more cautious man might have hedged. He knew exactly which account was real, and he gave me the other one without blinking. He thought this was a courtesy meeting. He thought I was someone's bookkeeper. He thought the complexity of the instrument was the moat, that the 214-page contract was an impenetrable wall that would hold until closing. What he did not know, could not have anticipated, was that the coalition had retained me 2 weeks before the final board approval meeting, and that the board approval meeting had just been moved up by 5 days due to a municipal bond issuance acceleration. He was not the only one managing a deadline, but I was the only one who understood what the deadline actually meant. He didn't know the clock was already running, and he didn't know I had already called the Wire Origination Bank's compliance division that morning. 5 days. That was the window. Not 5 business days, not 5 calendar days, with weekends bracketing the edges and providing buffer 5 consecutive days, 72 productive working hours, beginning the morning I walked out of Garrison Holt's lobby and ending at 9 a.m. on the morning of the Meridian Tower final board approval meeting, at which point the deal would be ratified by a 12-person board The municipal bond proceeds would be released into the project's primary disbursement account, and the structural mechanics of the fraud would become, in the language of the attorneys who would eventually be called to dissect it, substantially consummated. Once the bond proceeds released, the downstream wire sequences would execute automatically within a settlement window that my access level could not interrupt. The trap would close. The minority stakeholders would be legally positioned exactly where Holt had engineered them to be: maximum exposure, minimum covenant protection, no exit. I had 5 days to make that impossible. I drove directly from the firm's lobby to my office, a third-floor walk-up in a converted textile building 8 blocks from the courthouse district, where the walls were exposed brick and the windows faced a courtyard that let in no direct sunlight after 11 in the morning. I preferred it that way. Direct sunlight on a monitor is a distraction, and in the 72 hours that followed, I did not want distractions. I spread everything across the 2 conference room whiteboards I had already begun, mapping the LLC chain diagram, the SWIFT account sequence log, the disbursement timeline pulled from the coalition's quarterly reports, and I stood in front of it, the way a surgeon stands before an imaging panel, looking not for what was present, but for what the shape of the present things implied about what was absent. The room was quiet. The building's HVAC system produced a low, consistent frequency that I had long since stopped registering consciously. A 60-cycle hum that became, in long working sessions, something close to white noise. My assistant had gone home at 7. The courtyard below was empty, and on the left whiteboard, in red marker, I had written a single number: 11. 11 wire transfers, out of 37, originating from a SWIFT code that did not belong to Meridian Title and Trust. I needed to understand what that second account was, where it terminated, and critically, who had signature authority over it. Because in a fraudulent escrow diversion scheme of this architecture, the account itself is not the evidence. Any sophisticated actor can construct a plausible explanation for a secondary disbursement account, a technical sub-account for cost segregation purposes, a lender-required reserve holdback, a title company internal clearing function. The account is the vehicle. What destroys the vehicle is demonstrating who owned it, who authorized the transfers into it, and what happened to the capital once it arrived. I needed the full chain of custody for every dollar that touched that second account. I needed it in 5 days. And I needed it in a format that a 12-person board, most of whom were not forensic accountants, could absorb in under 6 minutes. I mapped the room the way I would map it on the day of the meeting, assigning each board member a designation based on their publicly available financial disclosures, their professional affiliations, and their historical voting patterns on previous Meridian Project resolutions. 12 seats. I categorized them without sentiment, the way a navigator plots terrain. 3 were what I classified as informed insiders, individuals whose professional proximity to Holt made it statistically likely they had awareness of the secondary account structure, even if deniable awareness. They would vote to ratify the deal regardless of what I presented, and attempting to persuade them was not only futile, but tactically dangerous, because any signal that I was building a case would give Holt's camp time to construct a counter-narrative. Those 3 were not my targets. 4 members were what I classified as passive ratifiers, individuals with no meaningful stake in the deal's internal mechanics, present on the board for reputational and regulatory optics, unlikely to have reviewed the underlying transaction documents with any granularity. They would follow consensus. They were not my primary targets either, though they would be essential to the final vote count. The remaining 5 were my assets. 2 were representing fiduciary entities with independent legal obligations, a pension fund subsidiary, and a municipal endowment whose charter governance required them to vote against any transaction once material undisclosed. Risk was formally entered into the meeting record. 2 were independent directors with documented histories of voting against deal ratification when forensic irregularity was raised during the approval session. And 1, the chair of the board's audit committee, A woman named Theodora Blaine, who had spent 11 years at a Big Four firm before moving into governance work, was the room's single most important variable. Theodora Blaine was the key, not because her vote alone could determine the outcome, but because in a boardroom, the audit committee chair is the one person whose expression of concern carries procedural weight that the room cannot simply outvote. If Theodora Blaine raised a formal objection during the approval session and requested a tabling motion pending independent forensic review, the chair of the full board, a cautious man whose primary professional preoccupation was liability exposure, would have no choice but to honor it. A tabling motion would freeze the bond proceeds release. A freeze would give regulators time to act on the filing I was simultaneously preparing for submission to the State Financial Crimes Unit. The whole architecture depended on Theodora Blaine seeing what I was about to show her and understanding within 6 minutes that what she was looking at was not an anomaly, but a pattern. On day 2, the originating bank's compliance liaison called me back. I had submitted the SWIFT record request through the Coalition's pre-litigation discovery channel, and the liaison, a careful, deliberate man who spoke in the measured cadences of someone who had spent years calibrating his words for potential subpoena, confirmed that the secondary SWIFT code I had flagged was not a subaccount of Meridian Title and Trust. It was registered to a separate entity. Meridian Capital Advisory Partners, LLC, incorporated 18 months prior to the closing date of the Meridian Tower deal, in a state whose LLC formation statutes required no public disclosure of member identity. He could not tell me who owned it. He could tell me it existed and that it had received wire transfers totaling, across the 11 transactions I had flagged, $9,340,000. $9,340,000, routed through an entity that shared a name prefix with the legitimate escrow agent, differentiated by exactly 2 words, capital advisory, that would be invisible to anyone reading a wire confirmation at speed, under deadline pressure, without a reason to look. The mimicry was precise. It was the kind of precision that requires forethought, requires construction, requires the deliberate engineering of a structure designed to survive casual scrutiny while diverting a material fraction of the deal's capital to an undisclosed insider position. He thought his LLC structure was buried deep enough that a 5-day discovery window couldn't reach the bottom. He didn't know I had already identified the registered agent. The registered agent for Meridian Capital Advisory Partners, LLC, was a man named Philip Corso, operating out of a shared professional services office on the 14th floor of a mid-rise building in the financial district, the kind of address that exists solely to provide incorporation clients with a legitimate-sounding suite number and a mail forwarding arrangement. Registered agent services like Corso's are entirely legal, entirely routine, and entirely unremarkable until you map the full portfolio of entities they service and discover that 3 of the 7 LLCs registered to Corso's office in the prior 24 months shared a common thread. They had all been named as disbursement recipients in commercial real estate transactions structured by the same law firm. Not the same city, not the same asset class, the same firm, Holt, Carver, and Dade. The pattern was not a coincidence. Coincidence does not repeat itself across 7 figures and 3 jurisdictions, with the same registered agent handling the paperwork. I spent day 3 building the entity map. It covered the 3rd whiteboard, which I'd borrowed from the building's 2nd floor conference room and propped against the exposed brick wall to my left. The map was a directed graph, nodes and edges rendered in 3 colors: black for confirmed entities with documented transaction history, red for entities with confirmed capital receipt but unresolved beneficial ownership, and blue for the connections I could establish through public record cross-referencing, but could not yet prove in the evidentiary sense required for a formal regulatory submission. By 11 o'clock on day 3, there was very little blue left on the board. The red nodes were resolving, one by one, into black. And at the center of the graph, connecting every thread the way a keystone connects an arch, was a single beneficial ownership disclosure that Garrison Holt had filed voluntarily, routinely, as part of a professional ethics compliance submission to his state bar association 14 months before the Meridian Tower deal closed. He had disclosed a financial interest in a real estate advisory entity. The disclosure was technically compliant. It named the entity, stated the nature of his interest as a passive membership position, and represented that the entity did not engage in transactions that conflicted with his firm's active client representations. The disclosure was also, in the context of what I had now mapped, a document that proved he had known about Meridian Capital Advisory Partners before the Meridian Tower deal was structured. Not a suspicion, not an inference, a dated, signed, bar-filed disclosure connecting his name to the entity receiving the undisclosed wire transfers, filed 14 months before the transfers occurred. That document was going to be the first page of the evidence package I was assembling for Theodora Blaine. The evidence package itself required 3 more days to compile, cross-reference, and format, and I had exactly 2 days left. I slept 4 hours on night 3, woke at 4:30 in the morning, made coffee in the building's small kitchen down the hall, and returned to the whiteboards. The specific quality of that pre-dawn silence is something I have never been able to adequately describe to people who have not worked this kind of case. It is not peaceful, it is pressurized, the silence of a room where everything important is already known, and the only remaining variable is whether you can translate it into a form that will hold in a room full of people who need to understand it in 6 minutes or the moment is gone. I have worked in that silence many times. I have never made peace with it. I have only learned to use it. The package had 4 components. The first was the Swift account comparison ledger, a side-by-side table showing the 37 wire transfers, the originating account for each, and a color-coded flag for the 11 transactions that routed through Meridian Capital Advisory Partners rather than Meridian Title and Trust. The table was designed to be readable at a glance, with the fraudulent account number highlighted in a color that would register as anomalous to any eye that spent more than 3 seconds on the page. The second component was the LLC registration documents for Meridian Capital Advisory Partners, pulled from the state's Public Business Registry, showing Corso as registered agent, the formation date 18 months prior to closing, and the absence of any public member disclosure. The third was the Bar Association ethics filing Holt's own signed disclosure, his own words, his own dated signature connecting him to the entity. The fourth component was a single-page summary document drafted in plain language without legal or accounting terminology, describing the mechanics of the scheme in terms that a board member with no financial background could follow from the first sentence to the last without needing to ask a clarifying question. I wrote that summary document 11 times. The 11th version was 287 words. It was the right length. On day 4, I placed a single phone call that I had been calibrating for 3 days. I called Theodora Blaine's direct line at 8:15 in the morning, a time I had selected because it was early enough to precede her calendar's first commitment, but late enough to clear her transition from home to office. She answered on the second ring, which told me she was already at her desk, which told me she was the kind of person I had assessed her to be. I identified myself, named my engagement with the Minority Stakeholder Coalition, and said 7 words that I had chosen with the same precision I apply to every other element of this kind of work. I need 12 minutes before the meeting. She did not ask why. She said, 7:45, my office. And then she hung up. That was all I needed. The meeting was in 31 hours. Garrison Holt spent day 4 conducting what his calendar, which I would later see in Discovery, described as pre-closing coordination calls with the 3 board members I had classified as informed insiders. He sent a revised executive summary of the deal terms to all 12 board members, a document that was polished, confident, and structured to frame the board approval as a procedural formality rather than a substantive decision point. He had his associates prepare a presentation deck with 41 slides. He booked a private dining room at a restaurant 3 blocks from the meeting venue for a post-approval celebration dinner. He was, by every available signal, a man who was managing the final administrative steps of a deal he had already won. He was performing the closing rituals of a victory that had not yet occurred, a habit that belongs to men who have never been wrong about the outcome before and have therefore stopped treating the outcome as a variable. He made one more move that day, a move that I had anticipated, but whose timing still required me to recalibrate. His firm's general counsel sent a letter to the coalition's general counsel, copied to me by name, formally requesting that any third-party financial review materials generated during my engagement be submitted to Holt, Carver, and Dade for coordination review prior to their presentation to any board or regulatory body. The letter cited a confidentiality provision in the coalition's retainer agreement with the firm, a provision I had read, analyzed, and already discussed with the coalition's independent outside counsel, who had confirmed in writing that the provision applied exclusively to deal-specific attorney-client communications and created no legal obligation over independently gathered forensic evidence. The letter was not a legitimate legal demand. It was a warning. Holt knew someone was looking. He didn't know how much I had already found. And he didn't know that the letter, by arriving the day before the meeting, had done exactly one thing of consequence. It had confirmed, in writing, that he was aware a forensic review was underway and had attempted to suppress its findings before they reached the board. That letter became the 5th page of the evidence package. He thought the confidentiality letter would slow me down. He didn't realize he had just handed me proof of consciousness, of guilt. The boardroom on the 44th floor of the Meridian Tower Development Group's headquarters was a different species of room than the one Garrison Holt operated from. Where his firm's conference spaces were designed to communicate dominance, this room was designed to communicate legitimacy, a distinction that matters enormously in the governance world and which manifested here in the details. The table was round, not rectangular, a deliberate architectural choice that signaled equal procedural standing among its members. The chairs were identical, no elevated position at the head. The projection screen was centered on the north wall, with sight lines calibrated so that no seat had a better view than any other. It was a room engineered to make consequential decisions feel orderly, rational, and above reproach. In 40 minutes, it would be the site of the most disorderly, irrational, and reproachful event in the Meridian Project's 7-year history. I arrived at 7:43. Theodora Blaine's office was 2 floors below the boardroom, a corner space with floor-to-ceiling windows that looked east over the city in the early morning light, the skyline still transitioning from the blue-gray of pre-dawn to the harder, more declarative light of a working day. She was standing when I entered, not seated, which told me she had been standing for some time, the stance of a person who has been thinking in motion, processing something that does not sit comfortably. I placed the evidence package on her desk without preamble. She picked it up. She read it with the methodical stillness of someone who has spent 11 years at a Big Four firm, learning to receive bad news without letting it register on her face before she has finished forming a judgment. She reached the Bar Association disclosure on page 3. She stopped. She turned back to page 1 and read the swift comparison ledger again. Then she set the package down, looked at me directly, and said, "How certain are you?" I said, "The bar filing is his signature. The SWIFT records are from the originating bank's compliance division. The LLC registration is public record. I am entirely certain." She picked up the package again. She said, "Give me the summary page." I gave it to her. She read it once, folded it in half, and placed it in the breast pocket of her jacket. Then she said, "I'll need 60 seconds to introduce you to the room." The boardroom filled between 8:45 and 9 o'clock, the members arriving in the clustered, low conversation patterns of people who believe they are attending a formality. Garrison Holt arrived at 8:52, with 2 associates trailing him, each carrying document binders, each moving with the precise, rehearsed efficiency of people who had been briefed on their role in a closing ceremony rather than a contested proceeding. He took his position at the table, and even in a room with no designated head, he had identified and claimed the seat that commanded the room's primary sightline, the chair positioned directly across from the projection screen, the seat from which a presenter's eye contact would naturally find him first. He was wearing a charcoal suit and a tie the color of dried blood. He looked, at 8:52 in the morning, like a man who had already begun mentally composing his remarks for the celebration dinner that evening. He saw me in the far corner of the room and registered my presence with the brief, controlled flicker of an expression that a less trained observer might have missed, a micro-compression at the outer corners of his eyes, a quarter-second adjustment of his posture. Not alarm, not yet. Recalibration. He was deciding what my presence meant and concluding, I believe, that it meant very little. The meeting was called to order at 9 o'clock by the board chair, a deliberate, gray-suited man named Wallace Chen, who opened with the procedural acknowledgments that govern these sessions: quorum confirmation, agenda ratification, conflict of interest declarations. 3 members declared no conflicts. Garrison Holt declared no conflicts. I noted the declaration in my copy of the agenda with a single underline and said nothing. The agenda moved to the Meridian Tower Final Approval Resolution, and Wallace Chen began his prepared introduction of the deal's terms, the language measured and formal, the cadence of a man reading from a document he has read many times. He had reached the 3rd paragraph of his introduction when Theodora Blaine spoke. She did not raise her hand. She said, in the unhurried and entirely authoritative tone of someone exercising a procedural right she has exercised many times before, "Wallace, before we proceed to the resolution, I need to introduce a material disclosure item under Section 7.4 of our governance charter." The room shifted. Section 7.4 was the Audit Committee Chair's right to table any resolution pending independent forensic review of any transaction where material undisclosed risk had been formally entered into the meeting record. Every person in the room who understood governance procedure understood, in the 3 seconds that followed Theodora's statement, that the morning had just changed its nature entirely. Wallace Chen set down his papers and said, "The floor is yours, Theodora." She stood. She looked at me, and she said, "I'd like to introduce our independent forensic reviewer, who has a brief presentation for the board." I walked to the front of the room. I connected my laptop to the projection system. I brought up the Swift comparison ledger, the side-by-side table, color-coded, 37 wire transfers, 11 flags. And then I did the thing that I have found, in 19 years of this work, to be the single most effective technique for communicating forensic findings to a non-specialist audience. I said nothing for 8 seconds. I let the table sit on the screen. I let 12 sets of eyes find the color-coded flags on their own, let the pattern register without narration, let the room do the interpretive work before I provided the framework. In those 8 seconds, 4 of the 5 board members I had classified as assets leaned forward simultaneously. The 3 informed insiders did not move. Garrison Holt looked at the screen with the expression of a man who has just heard a sound in the dark that he cannot yet place. I walked through the 4 components in 5 minutes and 40 seconds. I did not editorialize. I did not characterize Holt's intent or use the word fraud. I presented the Swift records as the bank's compliance division had provided them. I presented the LLC registration as the state's public business registry had filed it. I presented the Bar Association disclosure as Holt himself had signed it. I presented his firm's suppression letter as his general counsel had sent it. I placed each document on the screen long enough to be read, not long enough to be interrogated, because the goal in that room was not a verdict. The goal was a tabling motion, and a tabling motion required only that the audit committee chair have reasonable grounds to request independent review, a threshold that the evidence cleared by several orders of magnitude. When I reached the plain language summary, the 287 Word document I had written 11 times, I read it aloud, slowly, and then I stepped back from the screen. The room was silent for 4 seconds. Then one of the fiduciary representatives, the pension fund subsidiary director, said in a voice stripped entirely of affect, "I need to abstain from any vote on this resolution pending legal review." The municipal endowment director said the same thing, almost simultaneously, as though the words had been calibrated to arrive together. The two independent directors with documented forensic review voting histories looked at each other with the brief, bilateral acknowledgement of people who have just seen something confirm a long-held professional instinct. And Theodora Blaine said, without sitting down, without raising her voice, without any performance of drama whatsoever, "I am formally invoking Section 7.4 and moving to table the Meridian Tower Approval Resolution pending independent forensic audit of the escrow disbursement chain. I am simultaneously notifying the board that I will be transmitting this evidentiary package to the State Financial Crimes Regulatory Unit within the hour, as required by our charter's mandatory disclosure obligations." She paused. "Wallace, I need a second on the motion." End quote. The second came from the pension fund director before the sentence was fully complete. And then Garrison Holt spoke. He had been silent for 6 minutes, the precise duration of my presentation. And when he finally spoke, the words he chose in that moment were the words of a man whose internal model of the situation had not yet caught up to the reality of the room he was sitting in. He said, "This is a bookkeeper with a spreadsheet and a vendetta, and I will not allow a routine administrative audit to derail a $400 million transaction that has taken 7 years to build." He said it with the full authority of a man who had been the most important person in every room he had entered for 30 years. He said it to a room that had already moved past him. The motion to table was called. It passed 7-3, with 2 abstentions. The municipal bond proceeds did not release that morning. The celebration dinner reservation was never collected. What followed in the months after that morning is a matter of public regulatory record, and I will describe it only in its structural outline because the details belong to proceedings that are still, as of this telling, partially ongoing. The State Financial Crimes Unit opened a formal investigation within 72 hours of Theodora Blaine's submission. The investigation subpoenaed the full transaction records for the Meridian Tower deal and, within 30 days, expanded its scope to include 3 prior commercial real estate transactions structured by Holt, Carver, and Dade, each of which featured a registered agent entity sharing characteristics with Meridian Capital Advisory Partners. Garrison Holt's Bar Association referred his ethics disclosure to its disciplinary committee, a process that moves slowly and lands heavily. His firm's primary lender suspended its credit facilities pending the investigation's resolution. 2 of the 3 board members I had classified as informed insiders retained personal criminal defense counsel within the week. The minority stakeholder coalition, the 7 family-run real estate trusts who had come to me with a box of documents and a texture of wrongness they could not yet name, retained their equity positions in the Meridian Tower project, which was eventually restructured under independent receivership and completed 31 months later, under governance terms that bore no resemblance to what Garrison Holt had engineered. I was back in my office by 11:30 that morning. The whiteboard still held their maps, the LLC chain, the Swift ledger, the color-coded board member grid, the directed graph resolving from blue to red to black. I photographed them for the file and erased them in order, left board to right, the way you close a case methodically, completely, without ceremony. The courtyard outside was getting its first direct sunlight of the day, coming in at an angle that crossed the floor in a long, narrow rectangle. I made coffee. I sat down. And I thought about the 11 investors in that Port Authority deal 7 years ago. The ones who had been wiped out before anyone called me. The ones for whom the blueprint had worked because no one arrived at the room in time. This time, someone did. The numbers always tell the story. You just have to be willing to read them all.